What's up, everybody? What's up? What's up? What's up? What's up? Hit that like button as you come in. And tonight, you see the title, because today has been one of those days, and tonight I want to give it to you nice and raw. So, I've been asked several times about what it is that Sherar v. Cullen actually means and how it's applied, blah, 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 and what's stated in it. Well, most of us understand that Sherar v. Cullen means there must be an injury in order for you to have adjudication, which I've also explained to people in many of the videos that there must be an injured party. How you doing, William? And the second part of that is when you understand corpus delicti, you know, the Latin part of an injured party. Yeah, the corpus, the body of the crime. That is the one element that is the most necessary, because proving intent is one thing, which is the mens rea. A lot of us forget about the actus reus, which is the act itself. So when you're looking for the actual or the axis of the crime, and you're grabbing Sherar v. Cullen, and you're saying, what does it actually mean to have the injury? What is the injury? All right, I'm gonna keep it real simple for you. I've gone over things as simple as standing. And I'm pretty sure everybody remembers the one element that is required in standing is that you have an injury that can be traced directly to the actions of the one being accused or the defendant. Why? Because an injury can be to one's person, one's property, or to one's economics, which is why you have things such as a defamation, or exactly, no victim, no crime, which is also why you have things like defamation. Or a video that I'm going to put up in a couple of days is one that's called tortious interference with commercial expectancy. It's when you're damaging someone's reputation by doing things that are causing people to not do business with them. These are things that are economically damaging to a person. And if you also remember in standing, only the person injured can come into court for adjudication. A third party cannot come into court for adjudication or remedy from anything that they have not themselves been injured from, which is why when we're talking about police officers, and I think one of the videos I talked about where the officers themselves, actually the El Paso video, number 23, the El Paso video showed where I spoke about the other officers condoning the actions or supporting the actions of one of their fellow officers. They became actors in concert. It works the exact same way whether it's criminal or civil, which is why you have product liability suits, why you have lawsuits against, what's up, brother? Why you have lawsuits that deal with just corporations. And these things are things that need to be grasped and understood. So now, when we're setting up our case itself, one, you have to make sure you are the one injured, not someone else. And here's the greater part. So if someone is suing you, or if someone is taking you into a criminal setting, they have to be directly injured, or there is no crime. Because there's this thing called the confrontation clause. Again, the person that states that you did something, they had to have been injured. And then you have the right to confront them regarding this injury that they stated that you caused them. So when you're understanding it, The application is not a, I guess, a fortune cookie. It's not a cookie cutter. It's nothing simple. And unfortunately, if this is something that you're looking for, I'm not one of those that participate in the microwave society that we have. Everything that we do, everything that I talk about, everything that I speak with concerns a process. And that process is done line upon line and precept upon precept. There is no shortcuts to doing any of this. When you have a soldier that's preparing for war, he doesn't take shortcuts. She doesn't take shortcuts, because shortcuts get you killed. And death in this life, when you're talking about a court setting, is incarceration, is paying high fees, is doing things that leave you on things such as probation, where you're making monthly payments, where you got to make your freedom payments, or they're going to repossess you. So these are the things that have to be addressed. And a lot of times, most people don't want to take them out or even take the time, because they just want to do something that they've seen online somewhere. Because I believe many of you remember that I stated the reason why I started digging as deep as I did, and is still doing, is because a lot of what I was finding online, it wasn't right. And then you have people that'll go out and they'll spend tons and tons and tons of money with people that have never won a case. And just like I had a conversation with a young man a couple of days ago, and one of the things that he brought up, he was like, well, I was looking for this when I was looking for that. And he was like, well, what about your case? He said, we could talk about this and we could talk, but what about your case? I said, well, here's the easy. Let's keep it a buck, because it was a RICO case. There was more than 2 counts. The paper reported 2 counts, but each one of those counts was the deal that was offered. And the counts was actually a total of 13, because it was 7 pages long. Each one of the pages, under each one of the counts, had 8 separate counts. All of them had RICO, racketeering and influence corrupt organizations, and also the conspiracy for racketeering. So when you're looking at it, it totaled more than 100 pretty much charges. Each one of the charges, the deal, I'm going to say that one more time, the deal was 20 years per. No one in their right mind wanted to take the case, because, oh yeah, my brother was looking, and he got appointed an attorney who saw what I was doing and said, you know what, you are first chair. Which meant every time there was a question asked, I had to answer. I was pro se. My brother Alicia was pro se. Now, I look at it, it was like a basketball game. One of the things that we took apart was the fact that there were no victims. Alicia even said it in his closing argument. There were no victims. And he even stated to the jury, if there are any victims, if there were actual injuries, why was nobody able to take the stand to say that they actually were injured? That actually resonated with the jury, because at one point they were saying that we had millions of dollars of stuff. Okay, if we had millions of dollars, why is nobody coming to claim these millions of dollars that we had? Why is that? If they were victims, if we were doing something that was an actual crime, why was no one able to take the stand to say we did anything? And most people, when you're building these cases, you have to remember 99% of people that you are talking to or you're painting this picture for have no clue as to what you are talking about, because 99% of people have no clue what actual law is. which is probably why I keep getting asked the question about the application for Sherar v. Cullen and the injured party. How is that applicable to a crime? Because if we understand the three elements, corpus delicti, you can't have corpus delicti without mens rea or actus rea. You can't have a guilty act without a guilty mind or an injured party. If there is no injury, there is no crime. Because if there is no injury, there is no confrontation. If there's no confrontation, then what are we doing? Because any act that's done beyond that with no actual injuries, the people that are involved are now liable. Nobody wants to be caught holding the bag. That's why I tell you a lot of times you have to offer them an opportunity to cover their own ass. Allow them to get out your way, because nobody wants to deal with you when you're doing it the right way. But that does not require a microwave. Unless you're a drug dealer, then, the microwave might help you out a little bit. But this is not drugs. This is actual lifestyle. This is actual living. This is actually something that can be pressed. This is a home cooked meal. I don't give you snacks. I give you small bites of a real meal. And that's what this is. When you're taking apart your case, you're getting a whole meal. You get to sit down with steak and gravy and rice, potatoes, whatever, one of them. Because if you have both of them, you're going to be stuffed. Get your asparagus or some greens or something. That's what I'm giving you. I'm not giving you something that's bubbling up in the microwave because it's sitting in aluminum foil and saran wrap paper. I'm giving you something that you can eat with, that can fill your belly, that can actually send you home and give you the one thing that you want, and that's to be left alone, to govern yourself. So, I hope that everyone that had that question regarding Sherar v. Cullen, I hope that answered it for you. If it didn't, Godspeed. And for those that have questions, please do not hesitate to leave them for me. I appreciate you guys showing up, because I'm actually going to start doing more lives. I'm trying to work with a software called Switcher Go or something like that. But yeah, I'm going to try to get that together. But if you have questions, I definitely want to hear them. I want to make sure we all stay full. I want to make sure we all have the weapons that we need to go before and defend ourselves. I want to make sure we all eating good. All right? So, I love you guys. Appreciate those that were donating. We got 2 that are anonymous. One from Joshua. One from William. One from Gail. I can't remember the other one. And John, I appreciate you. I've got a couple of shows, because one that you're going to see tomorrow is regarding the interrogation techniques that are done by police officers, and you're going to actually see one that's done in the field, because I did the video regarding interrogation techniques, and I gave you all 9 techniques. Now, in this one, I believe he's only exercising 2. He's using 2 in a field interrogation. So you'll get a chance to see that tomorrow. I just watched the video with the dart guy. And I'm going to do a video on that one. That probably won't be up until next week. But it's also one that I feel is important, because most people don't even realize Dart apologized, because I'll get into it because it's legal. I'll tell you about all that. But lastly, the young man from the Dallas Cowboys that was arrested. That video will be up tomorrow, so be ready for that one, because that one is too easy. Because here's the thing. While I love the fact that out here where I'm at, for the most part, the policing is done right, But again, it only takes one bad apple to spoil the bunch. But when you're looking at certain practices, these things is where something like I'm speaking about tonight with Sherar v. Cullen really comes into play, because in the arrest video of, I believe his name was Darren Ross for the Dallas Cowboys, there was a lot of stuff that this police officer did immediately that was illegal, that made the arrest itself illegal. And we're going to have an opportunity to talk about exigent circumstances and not getting that warrant, and why, if anything, the arrest of Darren Ross can be thrown out. So be ready for that one. If you got any questions, hit me up. I love you guys. You want to send donations? It'll actually probably be in the comment section later on, because this was not really impromptu, but it wasn't well prepared. How about that one? Just understand, Sherar v. Cullen, there must be an injured party in order for there to be a crime. One of the elements of the 3 elements needed for a crime, which is also the main element of standing, which is needed for adjudication. If there is no injured party, there can be no confrontation, so there can be no adjudication. And no, I am not, what's his name? Johnny Cochran? Nah, that ain't my cousin either. So, but no adjudication, no standing. So, talk to you guys soon. I love you. Let's keep it going. Let's keep it growing.